Ready? Go ahead.
Good morning. On behalf of the Client Relations Department at Kimball, Tyree, and St. John, welcome to our inaugural roundtable discussion on the right to counsel in Los Angeles. My name is Michael Genovese, and I'm the Client Relations Director for our Los Angeles office. Before we begin today's conversation, I have a few important disclaimers to share. This training is for general information purposes only and is not intended as legal advice. Attendance at this training does not create an attorney-client relationship with the speakers or the firm they represent. For legal advice on specific issues, please contact an experienced KTS attorney. And the information contained in this training may not be duplicated in any way or duplicated in any other medium without the prior written consent of Kimball, Tyree, and St. John. With that, I am pleased to hand the floor over to our moderator for today, Nadav Zohar.
Good morning, everybody, and thank you very much for joining us this morning for this first-of-a-kind panel discussion. My name is Nadav Zohar. I'm a partner with our Los Angeles office and will be the moderator of today's panel. As you may know, taxpayers are funding millions of dollars for eviction defense through the Right to Counsel program. What started in 2021 as a $2 million pilot program to assist those who were truly impacted by COVID-19 has ballooned into hundreds of millions of dollars that are being spent with very little oversight on not only eviction defense, but also tenant solicitation relating to anti-harassment claims, habitability lawsuit, personal injury lawsuit, and other activities that often feel frivolous, abusive, and bullying in nature against landlords. Today we will give you the big picture, bird's eye view of the Right to Counsel program, how it came about into law, what is funding it, how it's impacting our industry, and more specifically, evictions and the landlord-tenant relationship, and what can be done on our end as members of the industry to reverse course, to soften the blow to our advantage. Before we start, I just want to remind everybody, if it wasn't stated before, that you have an opportunity to submit questions through the portal. We will try to address all questions in the manner in which they are received. If we don't get to your question, or if we cannot answer the question during this session, we ask that you don't hesitate to email us. You can email me or any of the panel members your questions, and we would be happy to respond. Briefly, before we start, I would like to introduce our panel for today. We have Chris Evans, who is the managing partner of the Los Angeles office. Chris has been with KTS since 1999, when evictions may have cost less than $500, and it took maybe 30 days to conclude, to where we are today, where evictions can be expensive, complicated, and time-consuming. Next, we have Mr. Lior Makiborski of Rome Investments. In addition to being a landlord in Los Angeles, Lior is the founder of Vibrant LA, a very special organization that we will discuss shortly during this panel. And last but not least, we have Ms. Salvina Turjikian and Mr. James Dorning. Both are partners in our Los Angeles office. Salvina heads our discovery department, and James, who just got here from court last minute, is our boots on the ground. He's one of our more senior trial attorneys. He fights our battles and he wins cases. Without further ado, Chris, I would like to start with you. If you can give a brief introduction to yourself, and also your experience as the managing partner. You're exposed to a lot of the numbers that our clients are interested in. We all know the difference between contested and uncontested matters, jury trials and bench trials, attorney represented and non-attorney represented. Can you tell us some of the raw data that you see?
Yeah, sure. And thank you, Nadav, and thanks for the panel. So the raw data that I'm going to give you is kind of a bright line between before the Tenants' Right to Counsel ordinance passed, which, Lior, was what, 2025, right around?
The initial one was 2021. The big money came in fairly recently.
Fairly recent, right. So we are seeing this kind of at the kind of midterm of 2025. And when I say big money, what we're looking at is prior to 2025, like Nadav said, you were looking in the single digits, millions, maybe 7 to 10 million. Right around 2025, you had an influx of probably in Lior will give us the exact figures, but anywhere between 170 to 200 million dollars being dropped into legal aid groups.
And that's per year.
Per year in the county of Los Angeles. So prior to this, what we were seeing was, it was busy. About 50% of our cases, if they got contested, were a jury demand. About 10 to 15% of those were attorney contested. Your average cost was about maybe $2,000 for a trial, and you were looking at maybe 3 to 4 months to effectuate an eviction. After the Tenants' Right to Counsel came in and this funding flooded some of these legal aid groups, now the numbers have gone up dramatically. So we're looking at about 85 to 90% of all of your cases that have an answer filed have a jury demand on the other side. And about 30% of those now are attorney contested. One of the ways to look at this in terms of the type of funding that's out there is KTS. Our firm is a statewide firm, right? We have over 125 attorneys statewide. We probably have 200 staff members. This money that's gone to the Tenants' Right to Counsel is like taking 2 fully staffed offices of KTS statewide and condensing them and putting them in the county of LA and giving them to tenants for free legal advice.
Well, and Chris, there's a difference between the percentage of tenants who are filing an answer with a jury trial in pro per, not represented, and then tenants who are filing answers with an attorney. Do tenants get help from court? How do they know to ask for a jury trial, and how is this impacting? I'm sorry to be so blunt, but the client's attorney's fees bill from our office.
Yeah, so one of the things we've seen with the Tenants' Right to Counsel is with all of this funding going into the groups, they've also been able to hire a lot of, I don't know if you call them lobbyists, but individuals who are closely connected to the courts. And one of the things they did early on was go to the websites and the kiosks where the tenants can go to download their answers, right? And they have put automatic language in every single answer that just demands a jury trial. Technically speaking, they're supposed to talk to their client and say, hey, do you want the cost of a jury trial, right? That's part of your job as an attorney. But these are now automatically filed, which is why you're seeing about 85 to 90% of every answer that's filed is demanding a jury trial. In terms of your fees, it's the biggest driver next to probably discovery, which Salvi will talk to. But the reason is as soon as they demand a jury trial, we have to be prepared by the court order on the very first appearance to have all of our jury docs ready. Right? And that costs attorney's fees. So we've seen contested cases go from around 2,200, which, is still a little expensive in my days, to double. And that's your average contested case, right? So it's doubled to about 4,200 to 4,500, but that's on a per case basis. It is common now to see cases cost $15,000 to $25,000 to litigate for a simple non-payment of rent case, where maybe they owe 1 month's worth of rent, but you got to spend $15,000 just to get them out.
Yes, and Chris, does this apply only to non-payment of rent cases, or are we seeing this type of over litigation of cases in cases that are not necessarily for non-payment of rent, or cases where the rent is very high, so it's not an affordable unit, it's not necessarily a low income tenant?
Yeah, we're seeing it across the board. Technically, the tenants have to qualify for the right to counsel. They have to have 80% of AMI as their stated income. We don't know if this is being double checked, but we've seen it across the board. And James, you've probably seen it at trial. I mean, you get as much attorney representation when a tenant threatens to kill a landlord or is doing has a meth lab running in their unit than you do a pay or quit, right? The chances of a tenant being represented is probably about the same.
We'll have recently had a case where a tenant was incarcerated for a number of years and still receiving representation by defense counsel to keep this unit open for whenever they're released.
Right. And so you're seeing it for not just basic non-payment, but again, really serious threats to health and safety. Or, I mean, it could be, we have individuals who are fearful for their life of stalking, but they're still getting representation. And there's no attempt to move these cases along. Every single case is delay and drive up costs.
Thank you. And Chris, we'll get back to you on several other points. I'd like to address Mr. Lior Makiborski, who is a landlord and the founder of Vibrant LA, a local organization that is involved in local politics. Lior, if you can please introduce yourself, the organization that you founded, and please tell us, how did the tenant right to counsel come about? What is funding it? And how do you see this play out in our industry?
Thank you. Good morning, everybody. So, like Nadav said, my name is Lior Masaborski. I'm a landlord in the city of LA. We own apartments exclusively in the city of LA, mostly RSO, so we're very familiar with this issue. I started Vibrant LA a couple years ago as a political advocacy organization that has mainly just one goal, which is electing sensible, moderate people to local office, because that's where we believe the decisions are made that affect all of these issues that have to do with our daily lives, not just the sidewalks being paved, but the issue before us. The right to counsel, like Chris said, was an idea passed by ordinance in 2021. It was brought about by some fairly extreme members of city council. I'm sure the audience knows who those people are. It didn't really have a funding mandate at the time. It was cobbled together. It was about $7 million from the general fund and some different agencies. So $7 million, not much money. By 2025, it ballooned to $177 million. That is because in 2024, as most of you know, the city passed the ULA measure, also known as the mansion tax.
If you can just briefly explain what ULA is for those who are not familiar with it.
So ULA is a tax on any property sale in excess of, I believe today it's about 5.4 million adjusted for inflation, and it ratchets up when you get over like 10.5 million. This was sold to the voters as a homeless resolution, right? We are trying to build housing for homeless people. We're trying to stop housing, or we're trying to stop homeless. Obviously, like many good intentions, it's not really going as planned. About like I said, 177 million was allocated towards right to counsel because in the measure, it drew a nexus between evictions and being homeless. So the thought is that if you were evicted, you will become homeless. Therefore, we need to stop evictions. And we need to educate all tenants on their rights and what is an eviction, what is harassment, etc.
So initially then, that money was earmarked for, let's build more housing, let's build more shelters. How did it get converted to, okay, now let's pay tenants to contest evictions? How did they draw that nexus? What was the point of that?
Well, look, this is part of a broader narrative within a certain kind of extreme faction within the city of LA, and honestly, a lot of major cities nationwide that is generally anti-landlord. They believe that housing should be run and owned by the public. It should be socialized. So this is just a tool in that box. Now, also maybe realizing that of the $1 billion or so that ULA collected, the city couldn't actually build the housing for many, many reasons. So let's do some other things that are, in their mind, tangential to this homeless initiative. So, like I said, I started Vibrant in order to put more sensible people into office, and the reason that's important here is because these elected officials decide on that budget allocation. right? And they decide on audits. This money has never been audited. The city attorney, the current city attorney of LA, Heidi Feldstein Soto, was on record not keen to approve this allocation, not keen to sign off on this because the city never received an audit of, for example, the $107 million that was directed at LAFLA, Legal Aid Foundation of Los Angeles. Where did the money go? We know it went to LAFLA, but we don't know really what the results were, nor do we know at the end of the day, did this really help alleviate the homeless situation in Los Angeles?
So when you're saying there's no audit, I mean, what we're seeing in trial a lot is prior to the tenant's right to counsel, we understood it to be like, maybe a cap of $500 per case. They moved the cases along quickly. It didn't do them any good to sit there and over litigate a case because they weren't going to get paid money. Now, when you're saying there's not an audit, are we saying that they just get to submit their bill to the city and the city pays without any supporting documentation? Because what we're seeing now is that every single case gets litigated to the max, and it seems to be that there's an incentive for them to bill and bill and bill and not process a case.
Correct. Yeah, I mean, look, what we're seeing is when we request information, we get the invoice, but it's not like myself or many of your clients where there is a principal on the other end of that, email or whatever chain who is penny wise and saying, wait a minute, this hour that you billed here, I don't really think that was an hour. This is a city kind of administrator who is probably not even geared for looking over legal bills. They're just approving things. And if legal aid says, hey, we need X millions of dollars this month to pay all of our attorneys for all of these cases, okay, yeah, that makes sense. And you're, like you said, you're seeing that.
Yeah.
Do we need all of this discovery? The legal aid says we do.
Yeah.
And we experienced this in court as before all this money was poured into the eviction world, a case would settle maybe on the first or second appearance. In extreme scenarios, it would prolong even more if the attorney who represents the tenant doesn't have a lot of client control. But now we're seeing that the starting point is the tenant's attorneys are not settling cases. Instead, they want to stretch the case as much as possible, to over-litigate, to do discovery, law in motion, multiple continuances, and then right before trial, they may accept the same offer that was presented to them at the very first appearance. And it looks like the system is built in a way to encourage the tenant attorneys to just over-litigate, because when you over-litigate, your attorney's fees invoice to the city grows. Thank you, Lior. And
well, I'll just add to that for a second. This is an inherent conflict of interest. You have a tenant who, in California, is owed a fiduciary duty from their attorney, is not the one paying the attorney, but is still owed that duty, is not receiving that duty, and I think there's a lot of room here for bar inquiries, and you have a city who's paying the bill. So this is an inherent problem.
And you see that again in just the jury demands. I mean, they're just automatically demanding without any client consultation. If we as a firm took one of your cases and just filed a jury demand for you without talking to you, we could be subject to bar complaints. You would be pretty upset because, okay, now you just demanded a full jury trial. I got to take 3-4 days off of work. I got to convince 12 jurors. But on the tenant side, it's just automatic, no consultation whatsoever with the tenant, because from what I'm hearing here, we get paid for it. The city's not going to ask us, why do you have a 100% jury trial demand? Why are we doing this? So yeah, there's a conflict of interest that's out there that we're seeing that's very disturbing.
yes, and we're seeing this in court, and James, you'll be able to address that as well. Salvina, good morning.
Good morning.
Salvina, you are with our discovery department, which is the heart of the case that's being contested. When we first started working together, you were a one-woman show in the discovery department, but today you oversee a staff, and that's because there's so much more discovery work, so many more contested cases. If you can please share with our audience some of your experience and how this impacts our cases and our clients.
Thank you for the introduction, Nadav. The litigation landscape has significantly changed since the program passed. These cases, they've historically been summary proceedings, but now they're increasingly being litigated like general civil cases. And that's having an impact in many ways. Attorney's fees are skyrocketing. We get discovery in a case, and that's automatically an increase in fees of several thousands of dollars. And it's causing delays in a case, and it also results in defense counsel dissecting these cases in a more detailed way, and they're spotting issues. So whereas before, there's a problem with the case, maybe we could have gotten away with it and gotten a nice settlement, but now they are dissecting these cases, looking for specific issues, and then filing motions that essentially kill the case. And just to backtrack a little bit, what is discovery? We hear this word a lot, but it's essentially the stage in a case where the parties conduct an investigation. So we're getting these answers filed by tenants, and like Chris said, they're going to a self-help center and they're just checking off so many boxes, even things that have no relation to the case at hand, like defenses that don't apply. We're getting answers that are 30, 40 pages long. But discovery is when we say, okay, you're alleging this and that. Well, where's the documentation? Who are the witnesses? What facts supports these claims and defenses? On the flip side, they're also doing the same to the plaintiff or the landlord. So whether it's a nuisance case, non-payment of rent case, they're asking for all of this documentation. They're noticing depositions. That's another form of discovery. Another type of discovery that we see, although it doesn't happen as often, it's happened maybe a few times this year, but it's property inspection. So they'll say, okay, we're coming to your property. We're going to inspect common areas and the unit. But on a positive note, that means we can also go in with your maintenance teams. We can take photos, we can take videos. And if you're dealing with a tenant who's denying access, this is a great opportunity for us to get in and inspect the property.
When this kind of first hit, I first realized it was impacting discovery because I'm seeing emails from you and your team at like 2 a.m. and we're like, we're overloaded. We're getting 100-page meet and confers. For the executives out there and the boots on the ground, this took us back a little bit. We had to adapt. We had to hire more. How do you see this impacting, the on-site or the mid-level? Because they're really the ones that we're sending all these requests to, saying, I need all these documents. How does it impact the client's business model from your perspective?
I think, one of the factors is early on in the year or whenever you're working on your budget, keep in mind that it's almost a guarantee that you're going to get discovery in your case. And if you do, it's going to increase fees. So please keep that in mind and try to plan accordingly. As far as higher ups, discovery is so time consuming. It really can be a burdensome process. We try to make it as easy and smooth as possible, but please keep in mind that your on-sites, if they're working on discovery, it takes a lot of time and it can be stressful, especially if an on-site gets noticed for a deposition. But another thing that we can do is just be proactive. I'm really proud to say that KTS has a great education department with so many different trainings that are available, and we can also tailor trainings depending on, what defenses or issues might be most applicable to your property. So if you have an RSO property, we can tailor discovery specifically for RSO properties. Maybe you guys need training on the just cause ordinance. We can provide tailored training on that. Education is, I think, the best way to kind of get the upper hand on these issues because, if your team knows what the requirements are, that will help us better litigate your cases.
Yeah,
and
we've seen that. Yeah, I think part of it. Yeah, and part of it was that, prior to the tenant's right to counsel, you had an understaffed defense bar, right? Understaffed. They weren't hitting all the issues. Now what they're doing is they're overstaffed practically, and James could probably talk to this a little bit. But, we might have 2 attorneys on the other side, but we have 1 on our side, 2 on the other side, sometimes sitting through trials with multiple staff and assistants. And so, no, LA is very complicated to begin with, right? We have to potentially pay security deposit interest. We need rent registration. We need to serve the tenant's right to counsel. There's 7 or 8 different things that we need to do just before we serve a notice. And if we miss a single one of these, chances are the other side now with this funding will find it, but they'll hold on to it. It's not like they're going to bring it up to us right away and say, okay, let's resolve this. They're going to wait to the very last moment to bring it in when the fees have already increased. So this education as it relates to tenants' right to counsel is so critical so that the team knows every single thing they need to do in order to have a successful case, because there's simply no room for error.
And just as another added comment is, I feel, and Salvina, you can correct me, but the tenant attorneys are using the discovery process and the property inspections and the request for documents also as a pretext to file habitability lawsuits, code violation lawsuits. I personally know various clients that call us right after we settle eviction cases that had the discovery department involved, get sued for habitability that triggers the insurance, and it creates another layer of burden on the landlords.
Yeah, we've seen that. I mean, earlier this year, we went to a deposition and defense counsel was asking all of these, trying to ask because we objected, we put an end to it. So they didn't get very far on this, but they were asking trying to ask a lot of questions about habitability. And we said, why is this relevant? It has no bearing to this case. But that's why, because there was an affirmative case at the same time. So it was essentially a fishing expedition. But going back to your prior question about what can clients do, another very practical tip is to have someone designated to work on discovery cases. I've noticed a few clients have done this, and it makes a difference in the cases. We're able to kind of work one-on-one with this contact and, say a problem comes up in one case or there's a requirement that maybe they didn't know about. We'll kind of do essentially a training. We'll go over what these requirements are, and then they implement changes at the property. So regardless of which asset or property is involved in a case, it's the contact that's assisting us. It's the same contact. So we're better able to kind of train them on what discovery involves and how to better approach providing us these documents and the information that we need.
So that's interesting that they're using this as a fishing expedition, because it's supposed to be eviction defense related to an eviction, not 110 ways to sue your landlord. I'm curious from Lior, when you're looking into this, does the tenant's right to counsel kind of an end in and of itself? In other words, this was the goal, they got the money, now they're going to be happy, or do you think this is a starting point kind of for more in terms of going after landlords and bigger policies in place?
The latter. Like I said, there's $177 million allocated. 107 was given to LAFLA for litigation. 22 million was given to Liberty Hill Foundation for tenant outreach. About $7 million was given to the Strategic Action for Just Economy, SAGE. You might have seen them at the various city council meetings. They're all in green shirts advocating for free rent. That $7 million was for harassment enforcement and education. Make no mistake, these groups are affiliated with the very elected officials that made the budget allocation. They are paying themselves. This is the best flywheel I think we've seen in LA. It is, if it's not technically corruption, it is de facto. It's the type of politics that we definitely see in other countries that I'm very surprised to see in the United States. This is a ton of money. Just for context, right? The city's budget is roughly 13 billion. 180 million exceeds the budget for many city departments. This is more than you get for Parks and Rec. I don't think people really understand the magnitude of what's going on and how ULA happened. It snuck in. People didn't think it would pass. They didn't understand that it would go to eviction and all kinds of stuff. People thought we were going to build all nice homeless housing. It's going for something else. It's perpetuating a political system. This is just the beginning.
Yeah, because there's only so much you can drop into eviction defense. At some point, you're going to get saturated, which we're close to in terms of the number of people hired. At that point, they have leftover money. It's got to go to something else. Well,
Correct. And I mean, you see that with some of these attorneys allegedly making $1,100 an hour. And I know eviction court's tough, but that's a lot. That's a lot of money on an hourly.
Yeah, that's a lot more than we charge, for sure. Nadav would love to charge that.
Oh, absolutely. Okay, thank you. And James, you are one of our more tenured trial attorneys. You take cases to jury trials if you cannot settle or resolve it. For the most part, you win,
Yes.
which is great. If you can tell us a little bit about your experience and also include a response to a very good question that was submitted. What can clients or landlords do to help be more successful in court and more cost efficient when a case goes to trial?
Thank you, Nadav. I'll address that question at the end then. My name is James Dorning. I've been practicing unlawful detainer litigation since about 2009. So I've seen the not so gradual change in the increase in defense bar, in the increase in jury trial demands, and the increase of just litigation in general. We're a long way from when I started. We could have, every case was 2 weeks, full money, no sealed record, to where we are now, where the de facto demand from the defendant is to be paid money, not owe any money, and have a dismissed record. What I've seen in the wake of the passing of the right to counsel program is that the defense firms are now flush with cash, and we see a significant increase in the quantity, though not the quality, of attorneys that are now on the opposing side. It's a lot of very young, inexperienced attorneys or attorneys who are trying to get on the bandwagon to get that cash grab of money that's being made available. They, particularly for the more established firms, the public interest firms, follow a script of how these cases are supposed to go with little to no input from their clients. We'll have a defense counsel come up and say, regardless of what the case is about, we want $25,000 for you to pay to our client to move out, and all your problems will go away. And it's easy enough for them to make this demand because they have no incentive for a quick and easy settlement, even if it's in their client's best interest. Their client could be there on a case for $3,000 to $5,000 in unpaid rent. Defense counsel can build tens of thousands of dollars by providing representation, demanding a jury trial, amending their answer midway through litigation, bringing a motion for judgment on the pleadings for some alleged defect. And some of these are challenging because the appellate court has modified a lot of the statutes to make it a little more ambiguous as to what a valid pleading would look like. They can bring a second motion for judgment on the pleadings because they don't have to bring them concurrently. They can bring them.
So they'll do it at the first hearing, they'll hold back the second deliberately, even though they could.
Yes.
Do it all at once for judicial efficiency, and then they'll wait till the continuance, which they know they'll get.
And then they'll get their continuance. They'll do discovery, which will delay the case, cost more time, cost more money, and at the end of that, maybe bring a motion for a summary judgment. And these are all dispositive motions, meaning it can kill the case at any step along the way. We'll get through all of those steps and still have to wait in line to be sent out for a jury trial. And along the way, we'll show up, we'll have an agent there operating in good faith to make a settlement offer. Defense counsel will be there, and their client won't even show up because they don't have to be there, and they won't have them there, and it makes them that much easier to not feel the pressure of coming to court, for not missing out on work, and it
How do
allows
they relay their settlement offers if their clients aren't even there?
Oftentimes they don't, and oftentimes I would speculate that sometimes they say they're going to and don't, but I've seen multiple occasions where we will make a settlement offer and defense counsel will immediately respond, that's not going to work for us. We need money for this case. And without even consulting their client. And these are good offers we're making, which are when we say good offers, obviously tenant favorable offers, because of the reality of the cost and the time and the risk of a case.
But as an attorney, like if you're given an offer, don't you have a legal like it's a legal requirement that you relay that offer to your client?
100% legal ethical obligation to convey an offer to a client, no matter whether or not I think it's good or bad, which is why oftentimes your managers will hear me say, I have an offer for you. I don't recommend it. I don't think it's good, but I have to convey it. Not everyone appreciates that aspect of their ethical obligation. This creates further delays, and the judges have been sort of inured to these delays, and they don't really seem to feel too much of the pressure to get these cases out the door as much as maybe they have in times past.
When you're making these offers and you're talking to opposing counsel and they're just flat out telling you, I'm not going to relay this, do they give a reason? Is there like somehow like, okay, I know what I'm doing is wrong, or do they tell you why they're flat out refusing to do their job?
It depends. I've had different anecdotes on that. We'll have some firms will say, well, this is all our bosses will allow us to do. My superior attorney has to approve this, and they won't approve me making an offer without money. Some have gone so far as to admit that on the record, and unfortunately, nothing's been done about that. Other attorneys will say, I've talked with my client and they can't do this, so they're not willing to do this. One attorney admitted to me that this is what they're told to do in their training, that they're following the script of demanding money and and just delaying the case as long as possible.
So the decisions are not made based on merits or the defendant, the tenant's decision and what they want. It's more a boilerplate umbrella policy that they employ on all cases.
Generally, yes. There are a few attorneys who actually do care about their ethical obligation, but in general, the incentive is not for them to end it quickly. They have a whole budget to burn through now. So discovery, motions, trial exhibits, motion. That's a good way to burn through $20,000, $30,000 on a $3,000 notice to quit, notice to pay rent or quit. What we also run into at the end of all of that is the bottleneck of available attorneys and available judges. So just in the last 45 days, I've been sent out to trial for a jury trial assignment 6 times. 4 of those settled, 2 went to verdict, and there are only so many of us, and there's only so many judges. And even though KTS probably has the largest pool of competent, skilled trial attorneys, there are more trials on a given day than there are attorneys available to take these cases out to trial.
Thanks, James. And do you agree that a lot of these evictions, the goal is to resolve them via settlement? Are you seeing that the settlement position from the other side, from the tenant attorneys, in addition to not communicating to their clients, the tenants, they are a lot less reasonable? Just for example, if a client already made the decision to waive rent and pay $25,000 and seal the record, what I'm seeing from our trial attorneys, including you, is feedback that says all these things are unconditional, meaning if the tenant doesn't vacate timely, if the tenant trashes the unit, if the tenant acts in bad faith right after the settlement is signed, the landlord still must pay the $25,000, must seal the record, and must waive the rent because they don't agree to what's called conditional or upon compliance. Is that what you're seeing?
I'm seeing that very frequently. That is almost always a condition demanded of opposing counsel, is to have the record sealed unconditionally and have rent waived unconditionally, no matter what happens between the date of settlement and the tenant vacating.
So just explain to the team here, what's the difference between a conditional and an unconditional?
So in an unconditional, generally what we're talking about, the way it comes up most often, is having the record sealed. The defendant ends the case with a settlement without the public ever knowing they had an eviction on their case. In every case, we are advocating for that record being sealed, condition on the tenant performing, and usually that's move out on the date you say you're going to move out.
Like if we're going to give you 60 days to move out, you better move out on day 60, or there's a consequence that your record will be unsealed and everybody will know you're under eviction.
Correct.
Right?
And that's
kind
the
of
condition.
to stick to the carrot, right?
Exactly. And that's really the only leverage we have to ensure that the defendant will be out on that time, because the sheriff's office can be unpredictable. Yeah. They have a high number of cases, and they've significantly reduced the number of officers assigned to doing this kind of work. So a lockout can take anywhere from 3 to 4 months. So if our client is giving the benefit of waived rent or reduced rent or a sealed record or anything like that, what we're asking for is some guarantee that we are going to get the benefit of the bargain.
And that's a red line for them. They're like, we're not even, that's one of the ones where they were like, we're not even going to bring that up to the other side. We've already decided for it, our clients.
In many cases, when it gets to that point, there are, yes. We've only had a couple of cases that went to trial over just that issue, but it can happen because some people are so obtuse about that.
But they also don't go to trial on that issue because a lot of our clients end up agreeing to the unconditional waiver of rent and unconditional sealing of the record just so that they can resolve the matter.
Yes, the time and the expense turn it into a war of attrition. And the landlord has a lot to lose because they're having to pay every step of the way, in addition to having foregone rent every step of the way. And so at the end of the day, if what's being offered is the risk of going to trial, and there are literally 100 or more defenses in an unlawful detainer, plus the additional time and expense, they know, well, we are going to get possession eventually because we will have a judgment for possession that the sheriff will conduct. And we're just going to have to hope that it'll be at around the time the defendant's supposed to leave. But of course, defense counsel wants a consequence-free environment where if they're not out on time, nothing happens. They just have to wait till the sheriff shows up.
And just for the second component of the question, can you tell our audience, our clients, our landlords, what can they do that will make your job easier? Just as an example, the on-site agent that appears in court, I'm assuming needs to be a little bit more sophisticated and knowledgeable about the facts so that they can be a good witness when you need to take a case to trial.
Yes, I would say my best advice is an ounce of prevention is worth more than a pound of cure. The agents who come to court, we're of course there to walk them through the process, help them know what they need to know. But we can only work so much with the foundation of what we have to make sure everything was done correctly in the pre-litigation phase, as far as the appropriate filings, security deposit